application in the matter of TAQA Bratani Ltd and others, and Fujairah Oil and Gas UK LLC.
Yes, good morning, Mr. Ellis.
May it please the Court, I appear with Mr. Venkatesan for the appellants in this matter, and my learned friends Mr. Nash and Mr. Hubbard appear for the respondents. Subject to the Court, we propose to break our submissions into 4 parts. First, I will make some introductory observations about the context in which the appeal comes before the Court. And second, I will deal with ground 1 of our appeal. As the Court knows, that concerns the identification of the transaction for the purpose of Section 238. Third, I will deal with ground 2, which concerns the learned judge's approach to the statutory defence found at Section 238(5). And the fourth part, Mr. Venkatesan will deal with ground 3, which concerns the quantum of the undervalue. And in that context, it's proposed that he will address our application to rely on new evidence. As the Court knows, that goes to the pensions point, which is the amount of the undervalue.
I mean, as presently advised, Mr. Allison, we don't really think that we get to new evidence. If the appeal is allowed, then obviously the whole question of remedy will have to be gone into in a reference back to the judge or a judge. And at that point, the new evidence will be no doubt of great interest. But the judge didn't deal with any of that. To my mind, at the present time, the difference between the figures in relation to the pension issues doesn't really affect your first 2 points. If your first 2 points are right, they're right. If they're wrong, they're wrong. And so I'm not sure we're going to get there. And while I'm speaking, I'm not sure 2.5 days is necessary for these interesting but not necessarily lengthy points. I mean, you have to overcome the hurdle that the judge made a series of incredibly favourable findings to Mr. Nash. And those are findings of fact. And you have to get over that hurdle because at every turn she found in their favour. And you have to persuade us that a transaction is really a dividend, and that's the beginning and the end of the case, I think.
My Lord, that's incredibly helpful, because I think the indication then is the quantum. The judge, of course, did find there was an undervalue, but ground 3 relates to the quantum of the undervalue. Yeah,
well, I mean, we would not be deciding the quantum of the undervalue with all that new evidence, and I mean, you know, even without the new evidence, it's incredibly complex. I mean, if she's gone wrong, either in law, I mean, I don't think you say the judgment is perverse on the facts.
My Lord, no, we don't. We say...
So you're hoist with a lot of facts.
My Lord, of course, we say, as the Court knows, we say in broad terms that the judge applied the wrong test when working out what the transaction was, and then everything flows from that, including the findings of fact of the judge that we rely on to show that the statutory defence in our submission cannot succeed.
Yes. Okay. Well, the other thing while I'm talking is that we were discussing this morning the origins of Section 238, which, as you probably realise, is of some interest and understanding to some members of the Court. And this all came from the Cork report. And I looked for my copy of the Cork report, but sadly, because I am so paper-free now, I have completely dispensed with all the old books that I used to know and love. And I may be able to find it somewhere, and it's not on the internet, but it would help us, for context and background, to see what the Cork report said about the purpose of these new provisions, because I remember fondly arguing about them. Now I'm afraid to say maybe 40 years ago.
My Lord, we can, of course, get that. I mean, what one sees about the purpose of the provisions, I think reflected in the Court report and then quoted in Sir Roy Good's book, dealing with the points is pari passu.
And Millett's judgment in MC Bacon. And
precisely.
I mean, because the new cases don't really add much. And so I think going back to the beginning of what it was all about is something that is useful.
Well, we can certainly do that. Apologies, we don't have the extracts here right now, but we can do that as soon as
Anyway,
possible.
you take your own course, but I've said what I wanted you to have in mind.
Well, also in view of the court's indication on timing, clearly we will focus on grounds 1 and 2 and endeavour to move through it expeditiously.
Yeah.
If I can then turn to the introductory points
Yes.
that I wanted to make. The first point concerns the architecture of section 238, which the court will find at Authorities Bundle, volume 3, tab 27, page 997. Do forgive me. Now, it's common ground, as found by the judge in the present case, that there are 2 threshold questions for any claim under section 238. The first is that the company must have entered into a transaction at an undervalue. That can be found at section 238, subsection 4. So the first is that there is a transaction at an undervalue. And the second is that the transaction at an undervalue was entered into at a relevant time. And for the court, the relevant time comes in 2 places. Firstly, in section 238, subsection 2, where the concept of relevant time is introduced as a gateway requirement. And then, if the court goes to page 1000 of the bundle, one sees that a relevant time, as found by the judge, has 2 requirements, one temporal and one substantive. The temporal requirement can be found at section 240, subsection 1, and in the present case, it's common ground that 1A is the relevant provision, and it's also common ground that Rockrose, the recipient of the dividend, was connected to UK CS8, the insolvent company, with the result that the transaction must have been entered into in a period of 2 years before the onset of insolvency. So it's common ground in the current case that the period is 2 years, and also common ground that the dividend was declared within that 2-year period. The substantive requirement can be found at section 240, subsection 2, and that is the requirement that the company must have been unable to pay its debts at the time of the transaction or as a consequence of the transaction. And as the court sees, that cross-reference is to section 123 of the Insolvency Act that the court will find at page 991 of the bundle. And again, it was common ground below that involves 2 different tests, colloquially called the cash flow test and the balance sheet test. At trial, the defendants mounted a sustained challenge on both grounds. They led factual and expert evidence to say that at the time of the dividend, UK CS8 was not insolvent on a cash flow basis, nor was it insolvent on a balance sheet basis. The judge found the company was balance sheet insolvent at the date the dividend was declared, and I should show the court those findings of the judge on that point. So in the judgment, core bundle, tab 7, page 183, so core bundle 183.
Could you just give us paragraphs in the judgment?
My Lord, of course, it's paragraphs 222 and 223. Could I maybe invite the court just to cast their eyes over those two paragraphs?
Yeah. Yeah.
So the court sees the punchline in the final sentence.
Yeah.
That the statutory presumption of insolvency is not rebutted, and in fact the judge had no real doubt that the company was balance sheet insolvent at the date the dividend was declared. Now in this court, the respondents don't challenge that finding, and it does follow, we say, the question raised by this appeal is whether a dividend of $84 million declared by a balance sheet insolvent company, while its creditors are left unpaid, should be clawed back under section 238.
Yeah.
The second introductory observation concerns the purpose of section 238, and of course I will need to come back in view of the court report point, in view of the question raised at the outset. The short point, though, is that as accepted by the learned judge below and not challenged as part of the appeal, the learned judge found that the purpose of section 238 is to protect the pari passu distribution of the assets of an insolvent company.
That's a rather general purpose.
My lord, yes, but breaking it down a little, of course, the pari passu principle is a fundamental principle of insolvency law, which operates to make...
I mean, that's all taken as a given. But what I'm suggesting is that 238 was new in the Insolvency Act to do away with a lot of the kind of argument that we've seen in this case. It was intended to be very simple.
To be clean.
And to be very clear that this is not what you did when you're... It's perfectly okay to do this if you're in fact rescued because of it. It's not perfectly okay to do it if the company then goes straight into insolvency and leaves 130 million or whatever it was unpaid and then cannot pay its creditors.
And I think what my lord's alluding to in that regard is the way that it was brought in as a streamlined version of 423, which was always there going back to principles of Roman law.
Section 1, what was it? Statute of Elizabeth. Was it?
Indeed, indeed. And now section 423 for transactions seeking to defraud creditors. But I completely understand.
But showing an intention to defraud creditors was very difficult. And that was why in the Insolvency Act they introduced section 238 and 423, which were intended to be easier.
My lord, we would absolutely agree with that.
They changed the preference provisions in 239 and so on. I mean, it's a miss of time for me, but it was meat and drink in years gone by.
And just the one point we do make from the pari passu principle, which it is serving a cleaner remedy to serve that principle, is that creditors share ratably under the pari passu principle and shareholders come last. Now, shareholders don't just come last, they come after the creditors are paid in full plus statutory interest at 8% on those debts. And we do say it's important because on the learned judge's approach, it's open to an insolvent company to pay $84 million to its sole shareholder, where but for the payment of that dividend, those monies would have been made available to meet the prior ranking claims of creditors within the insolvency. And as we will see when we turn to how the judge interpreted the statutory defence, we say that the judge wrongly thought section 423, the transactions defrauding creditors, and section 238, the cleaner undervalued provisions for office holders, were two sides of the same coin. The third point, by way of introduction, we make, and I'm sure the court will have seen this from the judgment, is that we advanced two additional claims below. We advanced a claim under section 423, transactions defrauding creditors, and we advanced a claim for unlawful means conspiracy. Now those claims were also dismissed by the learned judge. We didn't seek permission to appeal either from the judge or from this court, because we do recognise that this court would not realistically interfere with the factual findings which led to the dismissal of those claims. But we do say the distinction with the 238 claim, as we'll explain, is that the errors in that regard derive from a misunderstanding of the operation of the statutory provision, which, not just in this case but more broadly, has potentially damaging consequences for the clawback regime under section 238. Now, whilst noting that we don't appeal against those claims, we should draw to the court's attention, as we do in the skeleton, a number of developments since trial which raise further questions about the propriety of the transactions. Could we show the court, please, core bundle tab 2, page 25 in our skeleton? So paragraph 28 of our skeleton. Now we do this so as to ensure that we disclose to the court the possibility of any future claims, so it can't be said that bringing them in the future is somehow abusive. And there are two key developments since the learned judge handed down her judgment. The first concerns the reliance by the defendants at trial on a $250 million loan agreement, which is said to have been made available to the Fujairah group by Sheikh Zayed. The second concerns a payment of 6.6 million dirhams that Mr. Mazzagatti authorised on the 15th of December. That's the very same day the SPA was entered into between Rockrose and FIOGC.
Can I just understand why this is relevant? You say so that you're not shut out from bringing some future claim. What would the future claim be?
The future claim would be to set aside the judgment below on the grounds that it's procured by fraud.
Yes.
And in particular, just so I can show the court, of course, not asking for any findings of the court, to make sure that we have disclosed it properly to this court. The Sheikh Zayed loan was fundamental to a large number of the judge's conclusions. It runs throughout the judgment and takes a prominent role in the judge's factual findings. For example, it was the basis for the judge finding that UK CS8 would be able to meet its obligations under the joint venture agreements, and it was the basis for the judge finding that UK CS8 was not cash flow insolvent at the time of the transaction. And maybe I can just show the court two paragraphs of the judgment where that conclusion is reached. So it's core bundle tab 7, paragraphs 213 to 214, which is page 179 to 180. So 213 at the bottom, this is in the section of the judge's analysis of whether the company was cash flow insolvent at the time of the dividend. And essentially, the question for the judge is whether the cash flow insolvency problem, which otherwise was apparent, could be saved by parental support and or the Sheikh Zayed loan. And the judge said that could be taken into account when the company has a history of receiving support from its parent. And paragraph 214, there's the finding by the judge, referring back to an earlier finding I've already found, that the Sheikh Zayed loan could and would have been drawn down if necessary. So the basis for the conclusion within the judgment, in particular seen in the very last sentence of paragraph 214, was that parental to support was there through VRO, the ultimate parent company, because it had access to a $250 million loan facility with Sheikh Zayed. Now, the point that is relevant for future proceedings, that we therefore bring it to the court's attention today, is following the handing down by the judge of the judgment in this case. Sheikh Zayed made a public statement via his solicitors in England with us that he had never met Mr. Mazzagatti and never entered into any facility agreement with him. Now, why does that matter? It matters because if the loan didn't exist, then it necessarily follows that Mr. Mazzagatti gave false evidence below, and it would undermine the judge's factual findings, which place heavy reliance on the existence of the Sheikh Zayed loan. And therefore we formally draw to the court's attention that the appellants reserve their right to bring a claim to set aside the judgment on the ground it was obtained by fraud.
So why, I mean, I'm just thinking of procedurally, why you don't do that now?
The short answer to that is time and cost. In the event that we prevail before this court in relation to the undervalue, and if, as was said to the courts below, that the recipient of the dividend, Rockrose, is good for the money as asserted by Mr. Mazzagatti and Rockrose, that will in effect give us our remedy. We will recover the money that way. So it only becomes necessary if the money is not recovered by what we would say is the shorter statutory claim 238 within the context
I mean,
of this.
have you written a letter before action?
My Lord, there have been a large number of letters asking for explanations as to why these points were not disclosed and revealed to the judge. So there's been extensive correspondence on this point. I mean, we haven't troubled the court with that.
Is there a simple answer given as to why not?
My Lord, I think
I mean, it sounds pretty basic to me. I mean, the whole, as you say, the whole premise of it was that they had this large facility they could have drawn down, and therefore they weren't under pressure to enter into this deal and snaffle the 84 million. What do they say?
The short answer, I mean, of course I'll leave it for Mr. Nash later, but as we understand it, the short answer is Mr. Mazzagatti does not accept what Sheikh Zayed has said in relation to the loan.
Well, there must be a document. Do they rely on a document? Did they show a document to the judge?
There was a loan agreement shown to the judge, yes.
There was?
Yes, my Lord.
Okay. With his signature on it?
My Lord, yes, although he says nothing, he says he was not involved in it.
He said
his signature and his seal.
His seal?
Yes.
Right, that's good old-fashioned stuff.
Yes.
Good. Well, there we are. We probably can't resolve all.
No, we're not for a moment suggesting the court can. The second point that we raise in paragraph 28 of our skeleton argument is the 6.6 million payment that was made on the 15th of December. That was made on the very same day that the share purchase agreement was entered into. Our case at trial, as the court knows, is that the purpose of the sale was to dump UK CS8 by selling it before it defaulted on its obligations. Now, shortly after the sale, an individual named Mr. Almeri became a director of UK CS8, and it has emerged since the handing down of the judgment that on the very same day of the SPA, Mr. Mazzagatti signed a cheque request authorising a payment of 6.6 million dirhams to Mr. Almeri, who appears to have been...
What is that said to be?
My Lord, I'm so sorry?
What is that payment said to be for?
It is not. It was not in the action below. If I can just explain how it arose.
What do you say it's for?
Well, we say it has all the hallmarks of a kickback to enable a transaction to go through.
Shall we call it a bribe? Is that what you say?
My lord, yes.
Yes, I see.
Now, Mr. Mazzagatti has recently admitted in other proceedings alleging fraudulent conduct brought against him that he did sign the cheque request form on this day. Now, in other proceedings, that reference is there is a claim pending in the Commercial Court in London brought by a Singaporean company, API, of which Mr. Mazzagatti was formerly a director, alleging that he dishonestly misappropriated some 143 million euros from API.
Sorry, I'm a bit left behind. What? Just say that all again.
My lord, of course. The 6.6 million payment,
Yes, got that.
made on the same day,
Yes, got
not
that.
disclosed in our action,
Yes.
not disclosed to the judge below, not mentioned in his cross-examination, even though he was cross-examined in detail as to what he did on the 15th of December itself.
Yes. Now, I've got all that, but what I haven't got is the 143 million. That's
My lord, thank you. I'm so
appeared.
sorry.
Euros, I think.
I'll come there now. There is a claim pending, not brought by us, brought by a Singaporean company called API in the Commercial Court at the moment.
By API against whom?
Against Mr. Mazzagatti, amongst others.
Yes.
In that claim, it is alleged that Mr. Mazzagatti dishonestly misappropriated 143 million euros from that company of which he was formerly a director.
Right. When?
Well, maybe I can get back to my lord about the precise details. The important point is
This is all new to you.
the detail. Yeah, my lord, this payment absolutely, and the reason it's new after the judgment is this: in those proceedings, API alleged that the 6.6 million dirham payment to Mr. Almeri was made using API funds. So in other words, it's alleged that he took API funds to use to pay to someone in the context of our transaction. Mr. Mazzagatti initially denied any knowledge of the payment. But since the judgment below, in the API claim, there has been disclosure by API of the signed cheque request form.
Yes.
And as a result, Mr. Mazzagatti has amended his pleadings in that claim to admit that he did sign the cheque request form on that date.
And you say the money was paid by API. How was that? If it was a cheque request form for it to be paid by this company?
My lord, not by this company, paid by API.
It was paid by API.
Paid by API,
I see.
and paid to an individual who was a senior advisor
Almeri.
to the Fujairah government, who then became a director of the company
Right.
after the sale
Right.
So-
Almeri became a director.
of UK CS8 following its sale.
Right. Okay.
Now, just for the court's note, the detail in that regard can be found in the second statement of Mr. Ashley at pages 623 to 624 of the application bundle. And we draw it to the court's attention as another basis on which we may seek to set aside the judgment below on the grounds it's procured by fraud, including the concealment of what on its face appears to be a bribe paid to Mr. Almeri to persuade FAIGC to buy UK CS8. And again, we wish to ensure that it can't be suggested later on that we've waived the right to bring any such claim.
Yes.
They're the introductory points, and subject to the court, I was going to move to ground one, the meaning of transaction.
Yes, thank you.
And if the court would like to have the provision open again, it's Authorities, Volume 3, tab 27, page 996. Now, the first question we say that arises for the court, in particular as seen from subsection 2 and subsection 4, is to identify, is there a transaction? And if so, what is it? And there's a requirement that the company enters into a transaction. First, I wanted to identify to the court the rival cases that were pursued at trial, then show the court what the judge found, and then explain why we say the judge has made an error in the legal test that she has applied to get to the conclusion that she did. Now, as the court knows, our case at trial was that the transaction for the purposes of section 238 is the declaration of the dividend of $84 million by UK CS8 on the 24th of December 2020. We said, and we do say today, that that is consistent with the language of section 2384, which is focused on what is being done by the company. So UK CS8, it applies where the company has entered into the transaction. And we also say that our view of the transaction is consistent with the purpose of section 238, because it's looking at the insolvent estate of the company and it's concerned with the restoration of assets to the insolvent estate of that company.
Yeah.
Now, as the court knows, by contrast, the respondents contended that the transaction is not the dividend alone. They said it's the overall arrangement between Rockrose and FIOGC, pursuant to which the shares in UK CS8 were sold to FOIGC. So they start with the SPA. That's an agreement between Rockrose and FIOGC. It's a contract to which UK CS8 is not a party. Rather, it shares the subject matter of the SPA. And they say that the transaction is the SPA and all the linked steps taken to facilitate the sale. And they say that because the dividend was one element of the linked steps to facilitate the sale, one takes a broad view of the transaction. Can I just invite the court to turn up then what the judge said about those submissions and the conclusion reached by the judge. If we go to page 186 of the core bundle,
Paragraph.
my Lord, sorry, it's paragraphs 230 to 232. So after dealing with my submissions at 229 and discussion of Feekins at 228, could I just invite the court, please, to read 230 to 232?
We're
So-
quite familiar with those paragraphs. They're quite significant to the case, aren't they?
Of course. And as the judge finds there, and we see from 231 in clear terms, the judge identifies that the dividend was merely an afterthought, adopted at the last minute, in order to give effect to the prior agreement, i.e. the agreement between two different parties.
I mean, that it was merely an afterthought. I mean, to a cynical old judge, as you might describe me anyway, in this tribunal, seems slightly surprising.
Well, my lord, yes, but we have findings in that regard, and our 423 claim in that regard failed at trial.
Yes, yes, okay.
But what we say, we note and we share the surprise, but what we say for the purposes of today in this court is what the judge has done is telegraphed from the afterthought conclusion to then in the last sentence of 131 to say that that alone is enough when working out what the transaction is.
So last sentence of
My lord, I'm so sorry, 231.
231.
So top of page 187. So having made the finding, the afterthought finding, the judge says that is enough for the purposes of section 238 to mean that it would be wholly artificial to regard the dividend as the only relevant transaction in isolation from the wider arrangement to which it owed its very existence and with which it was inextricably linked. So,
But I mean, that seems to be spun off the cash and debt-free argument, doesn't it? That this was intended to be cash and debt-free, which is some kind of magic potion.
which I mean, I'm going to come to that later on, but as the court knows from the grounds and the skeleton, we say that that's wrong. One can't have some broad point of principle that cash and debt-free sales are always okay, and that then justifies everything else that one does to achieve a cash and debt-free sale. And essentially where, with respect, the learned judge went wrong is to find, because I've got a cash and debt-free sale agreed by two different parties, insofar as UK CS8 is concerned, which is the subject matter of the transaction, it has to do everything it has to do to achieve the purpose between the contracting parties, and 238 provides no remedy in those circumstances.
I suppose you say that completely ignores the section which demands attention on what the company is doing or
My lord,
what
yes.
is being done to the company.
My lord, yes. And consideration that is moving to the company. That's what the section quite properly, and I mean, one sees it so clearly on the facts of this case, when you have a wider group with an insolvent company, found as a fact insolvent company, UK CS8 within the group, the need to pay individual attention to the company, the insolvent company, when working out what the transaction is, what the consideration was, whether there's an undervalue, and whether the defence is engaged, are fundamental points. And we respectfully suggest that off the back of the cash and debt-free prior finding, the judge failed to engage with any of those questions as we say she should have done.
Yes.
So we say that, I'm so sorry, did the court see 232 as well?
Yes.
We say that approach is an error of law. We say that an orthodox approach of the relevant legal principles leads to the dividend constituting the transaction, and then everything else falls in behind that in terms of analysis. Now, the two key authorities we relied on below that we'll need to show the court again today are the House of Lords decision in Brewin Dolphin and the decision of this court in Sequana. We'll also need to show the court a recent decision of Lord Justice Miles reached in October of this year in the context of Section 423. And apologies,
a very long decision.
It is a very long decision, but mercifully a number of the issues within that claim do not impact on today. But we do say very clearly the judge's approach to what is a transaction chimes with the House of Lords in Brewin and the approach in Sequana, and is in distinction to the approach of the judge as we saw at 231, which is if everything's linked, then that's your transaction.
And you say it's not an answer to say this is all a factual question as to what is the transaction, which you can't get your screwdriver into on an appeal, because you say she's made a fundamental mistake of not looking at the transaction entered into by the company.
My Lord, yes.
She's looking at some transactions entered into for their own purposes by different companies.
My Lord, absolutely. We say that when one correctly applies the legal principles and works out what the transaction is, it shows that the judge has gone wrong as a matter of law, and we are not needing to challenge the factual findings. Indeed, the factual finding at 231 supports our case, we say, on a proper application of the legal principles. Namely, it shows why the judge has gone wrong.
Yes.
Can I, subject to the court, start with Brewin Dolphin? The court will find that at Authorities Volume 1, tab 4, page 44. This is a mercifully short decision. If I may just quickly guide the court through the facts of the case, which we can take from the speech of Lord Scott, beginning page 46 of the bundle, just below letter H. So there were two...
No, you say 46?
Of the authorities, my lord, yes.
Yeah. The company in the present case is A.J. Beckel.
My lord, yes.
Yeah.
So there was a company, A.J. Bell, wished to sell its stockbroking business to Brewin.
Yes.
Over the page at page 47, as a prelude to that sale, so it could sell the business, it hived down the business to a wholly owned subsidiary for a consideration of £1. The court will see that at page 47 by letter A. So it moved the business to a subsidiary, wholly owned subsidiary, BSL. And that was, as explained by Lord Scott again at letter A, so the sale could take place in a tax efficient way. There were then two agreements entered into by the company on the 10th of November 1989, and one gets the detail of those agreements between B and D. The first agreement was the SPA, under which the shares were transferred by AJB to Brewin. So in other words, they transferred the subsidiary across to Brewin. And they did that in return for Brewin agreeing to assume AJB's obligations to its employees, including redundancy payments. So that's agreement 1. Then agreement 2 between B and C is that Brewin's parent company, so the purchaser's parent company, PCG, covenanted to pay AJB a rent of £312,500 per annum for a lease of the computer equipment. Now, as explained by Lord Scott between C and D, of course, the total consideration under Agreement 2 was 1.25 million, and that was the price that had been agreed for the sale of the stockbroking business. So 2 agreements entered into by AJB, 1 the SPA and 2 the computer equipment leasing agreement. The problem was that the computer leasing agreement was in breach of the covenant in the head lease. One sees that at 146D, page 47D. Just below letter D, the court will see consent to the subletting out of the equipment by AJB to PCG had neither been sought nor given. So what happened was that head lease was forfeited and the lessor recovered the computer equipment. As a result, by letter E, PCG treated Agreement 2, namely the leasing agreement, as terminated and didn't make any of the rental payments under the agreement to AJB. Paragraph 7, AJB was in deep financial trouble and went into liquidation. Therefore, 238 was engaged. And paragraph 8, what the liquidators did was to commence proceedings under 238. Importantly, at first instance, the judge had made a factual finding. And one sees this at paragraph 9, page 48, heading the judgment of Evans Loan, J. And picking it up 6 lines down the paragraph, the court will see the sentence beginning the last word, the. And there's a factual finding by the judge that the 2 agreements, namely the share sale agreement and the leasing agreement, were linked in the sense that it was never contemplated that one would not be entered into without the other. Now, as Lord Scott observes, there's obviously an unintentional double negative in that sentence, but it is treated as a finding of fact by the trial judge that the agreements were linked and you would never have had one without the other. So that was the backdrop to the issues that the court was considering. We should show the court how the issue was addressed by the Court of Appeal before seeing what the House of Lords said about it. Could I ask the court please to go to page 49?
The Court of Appeal was upheld, was it?
No. On the transaction, yes, but on what could constitute consideration, no. So on the identity of the transaction, yes. So paragraph 16, page 49. A reference to the factual finding that I've just referred to. And then over the page, Morat LJ said that unless the sublease agreement could be said to be a sham, or unless there'd been an artificial division of the real transaction entered into by the parties, the form of the agreement into which the parties had entered would be determinative in identifying the transaction on which section 238 would bite. And then he identified the 2 issues before the court as being the value of the shares in BSL and the value of the consideration. Could I, at risk of asking the court to read a relatively large tract, just so you don't have to hear me read it out, read the two extracts from the judgment of Lord Justice Morritt and then the observation of Lord Scott at paragraph 17.
Yeah.
And so, pausing there, 2 points we say can be taken from the judgment of Lord Justice Morritt. The first is that the share purchase agreement constituted the transaction alone, and it did so even despite the factual finding of the judge that it was inextricably linked to agreement 2, the lease agreement. And the second point is the Lord Justice saying that the two agreements can't be the same transaction for the purposes of 238 because the parties to the two agreements were different. Now, the House of Lords endorsed the conclusion of Lord Justice Morritt that the transaction was the share sale agreement alone. And just to make that clear within paragraph 20 of the judgment, can I take the court, please, to below letter F, the sentence beginning at the far right-hand side, one must.
Yeah.
So what Lord Scott says is, one must obviously start with the share sale agreement. That was the agreement under which AJB agreed to divest itself of the allegedly valuable asset, namely the shares in BSL. And then what the judge does is to set out the statutory language, and one will see very clearly from the way in which it is done within the quotations that the transaction that is interposed into the statutory language by Lord Scott is the share sale agreement. So the company AJB enters into a transaction, in square brackets, the share sale agreement with that person, Bryn Dolphin, for a consideration the value of which. So that's the transaction. Where the House of Lords differed from the Court of Appeal was the next point, which is that the subsection doesn't stipulate the person or persons the consideration is to be provided by. And essentially that led the House of Lords to find that the consideration that could be taken into account did include the consideration under the lease agreement because it was linked to the share sale agreement and consideration moved to the company under it. And one sees the punchline discussion of that at paragraphs 20 and 21, and then the punchline at the end of 21, just above letter G. In my respectful opinion, that is a useful breakdown of the statutory requirements. And then this sentence, in the present case, the agreement for the sale of shares, i.e. the transaction, was entered into for a consideration which included the benefit of the sublease agreement. So when it comes to identifying the transaction, we say that the approach shown in Brewin Dolphin is not reflected by the approach of the judge in the present case. In fact, it's even more acute in the present case because UKCS8 was not even a party to the SPA, whereas it was in Brewin Dolphin, the company was. All it did was to declare the dividend.
So what does she say about this case? Does she get it wrong, do you say?
My lord, yes.
Or where?
My lord, we went through the case in...
No, I mean in her judgment. She refers to it, right?
But doesn't discuss it in the context of this point in any detail. There's only the reference in the part of the judgment dealing with the transaction.
Page 233.
233 talks about consideration.
So what she says there in that sentence is correct, right?
Yes, that's correct, because then one can almost draw a line under 232. That's where the judge finishes the analysis of what is the transaction. The judge then at 233 goes on to look at what is the consideration provided by the company. Of course, as made clear in Brewin Dolphin itself and the terms of the statute, they're two different questions.
Right.
And in the context of determining what is the transaction...
Did you say it ends at 222?
232.
Yes, I'm so sorry if I misspoke. At the end of 232.
Just pausing there. The judge says at 233 it follows that. And you say she's wrong about that.
My lord, yes, I do. It doesn't follow from the conclusion as to what the transaction is that the consideration can be wider. Rather, it follows from the House of Lords decision in Brewin Dolphin that you can take into account consideration under other linked agreements. That doesn't change the meaning of the transaction, but it allows you to assess the value of that consideration when working out whether there's an undervalue. So essentially...
The equivalent here would be the pension arrangements.
Oh, my lord, absolutely, because that is, of course, if then one follows it through, once the judge has made the consideration point, then at 236, that is the point the judge launches into. Because, to be clear, the only element of consideration that the judge found had been provided to UK CS8 for the declaration of the dividend was the release of a 39 million pension debt owed by another company. So that's why the judge still found there was an undervalue.
Yes.
Now, we say the judge, I'm going into ground three and I won't do it safe to say this, we say the judge was wrong to take that into account because we say it wasn't consideration provided to UK CS8.
No, but had it been, it would be equivalent to what they're talking about.
Had it been, then absolutely on all fours with Brewin Dolphin to take it into account as consideration, but not
As
to
what
change
the
the
transaction.
My lord, yes.
Okay, I think we got that. Yep.
And at the risk of repeating what the court saw from 231 earlier, is the judge jumped from the finding that the dividend was an afterthought and that the agreements were linked to meaning that that makes it a single transaction. And we say respectfully, Brewin Dolphin shows one that she was wrong to do so. The second case to show the court is the lengthy one. It's the Credit Suisse judgment. The court will find that at tab 26 of the bundle. So page 804 in the page 803 in the electronic bundle. Not referred to by the judge, of course, because it's handed down only in October of this year. It involved Lord Justice Miles considering and resolving a dispute on how to identify the transaction in the context of section 423 of the Insolvency Act. Now, when doing that, the learned judge paid regard to the authorities decided under section 238, as well as those under 423, on the basis there's no good reason for giving the transaction a different meaning in those two sections.
And you accept that's the case? Transaction should mean the same in both cases?
My Lord, we do. And indeed, we say that's consistent with a paragraph in the Supreme Court's judgment in the El Hosseini case, which is, for reference, it's authorities, tab 25801. I wasn't going to labour the facts in any detail at the moment, save to say to the court there is a helpful, pithy summary at paragraphs 1 to 7. I was going to instead turn to the part of the judgment concerned with, number one, what are the legal principles one applies when working out what the transaction is, and number two, the application of those principles on the facts of this case. I'm so sorry, can we go to 579 to start with, which is at page 910. Just to make one framing point for the court, this was also a case in which the defendants contended for a wider meaning of the transaction on the facts. They said that it included a series of contracts which were inextricably linked with the two contracts entered into by Greensill, the insolvent company. Whereas the claimant said, no, that's not right, that's too broad. The section is only dealing with the contracts entered into by the insolvent company. Now, the learned judge rejected the defendant's case just to show the competing arguments and the principles. 579, page 910, one sees the position of the claimants, that it falls to be identified by reference to the personal persons with whom the debtor entered into it, such that only the elements of the transaction between that person or those persons and the debtor may be taken into account. So that was the claimant's case. The defendant's case is at 580 to 582. And essentially, as we will see later, they contended that 15 linked agreements should be the transaction. And if one sees the submission made at the end of 582, the last two sentences, based on the Emmanuel case, the judge subsequently finds that their submission on that wasn't right, but he says they submitted by parity of reasoning, the debtor may be treated as a party to a transaction constituted by a contract to which he is not a party as a matter of contract law. Indeed, they contended more broadly that a dealing may form part of a transaction even where it does not involve or require the participation of the debtor. So they were the competing cases. The first thing the judge does at 583 is to say that to resolve those differences, he needs to consider the cases in more details. Perhaps unsurprisingly, he starts with and really focuses mainly on the Bruin Dolphin case. I think we can skip over his discussion of the case because we've already looked at Bruin.
But his conclusion is at 589.
My Lord, I'm grateful. I was going to show the court two things. I was going to show the court, first of all, just for noting, the discussion of a manual at 593. Why the judge says it's of little assistance.
Yeah.
Also for the court, I don't think I need to go into detail now, but the discussion at 594 through to 598 of the Court of Appeal's decision, that West Bank and Jones,
Yeah.
which again supports the finding that you're looking at what the debtor has done. And indeed at 598, you're also looking at the purposes. And then at 599, as mentioned a moment ago, one gets the distillation of the principles.
Actually, I referred to 589.
Oh my Lord, I'm so sorry.
Which was before you got to the discussion about Feekins, where he says that the passage from Morit continues to provide helpful guidance about the meaning of transaction. And he then says, but you've got to make sure you stick to the words of the statute, which is very orthodox. And then he deals with Feekins and Emmanuel, as you've said, and reaches those conclusions at 599. Yeah.
And in relation to, we'll see what the judge says later on as well about Feekins, because that's clearly the main case relied on by the respondents. At 599, we say is a perfectly orthodox application of the principles as distilled from Bruin Dolphin, and we do commend in particular Roman 5 through to Roman 10. So the court's looking at the statutory purpose of preventing avoidance of debts, that's 43, but then the fact that a series of steps may be interlinked, even in the strong sense that one step would not have happened without the other, does not mean that the entire series necessarily constitutes a single transaction for the purposes of section 423. And then over the page at 914, indeed the courts are likely to be reluctant to view a number of contracts involving different parties as constituting a single transaction unless the contracts have been artificially divided, picking up on the point made by Lord Justice Morris in the Court of Appeal in Bruin Dolphin.
Then it's 8, isn't it?
And then 8, absolutely, there must be a transaction and the relevant person must have entered into it.
Is it nevertheless a little bit less strict, possibly, than Lord Justice Morritt had been? Because Lord Justice Morritt seemed to focus simply on the single transaction into which the debtor had entered. And this doesn't seem to exclude the possibility that you could take into account something which the debtor had not been a party to, even in the absence of artificiality.
My Lord, I think our primary submission in that regard would be that is relevant as seen in the House of Lords decision. One is looking at consideration. From those other arrangements, did consideration move to the debtor? So is there a contract, for example, between B and C under which C pays A, the insolvent company? But we do say it's important to draw the line between transaction. Now, I don't dissent from the proposition that it can be, doesn't need to be a written contract, it can be an understanding, and that's clear from the definition of transaction, but as one sees from the way that was relied on in the Feekins case and how it's described in this case, one's looking at active steps taken by the debtor company in those understandings.
So just to be clear, if you have a question of whether an agreement between two different parties can be part of a transaction into which the debtor has entered, on your case, can it be or not?
My Lord, our primary submission is no, based on the reasoning in Bruin Dolphin and this case.
Subject to the artificial division.
My lady, yes. so they're the legal principles. Can I then, there's lots of other issues in this case, but can I then move to the application of those principles to the meaning of transaction?
And you said earlier that one of the cases you'd relied on below was obviously Sequana. We're not looking at Sequana at this stage.
My lord, no, that's the third case that I'm going to. I'm so sorry if I didn't make it clear. I'd start with Brewin Dolphin, and then Credit Suisse, and then Sequana. For, in essence, it's putting the case a different way, namely that makes it as clear as it can be that a dividend alone is a transaction.
Yes, I see.
Could we then move to page 922 of the judgment? So this is when the judge gets into determining the claim, and the first thing the judge deals with is what's the transaction. So page 922.
Sorry. So I'm looking in the,
I'm so sorry.
I'd gone to the judgment in this case, which is not what you mean at all. You mean Lord Justice Marr's judgment.
My lord, I do. I'm sorry. It's
Yeah.
tab 26,
Yes.
page 922.
Yes.
Thank you. And maybe I can just summarise the issue here. The judge deals with 2 points within this section of the judgment. First, the judge deals with whether the defendants were correct, as a matter of fact, to say that a series of 15 agreements were interlinked and should be seen as a package. The claimant said they shouldn't. The defendants said they should. And then, based on that finding of fact, the judge goes on to consider what is the transaction. So, in relation to the first point that the judge needed to decide, the judge finds as a fact that the 15 agreements did form part of an interlinked package, and that they stood and fell together in that one wouldn't be there without the other. That is identified as an issue at paragraphs 654 and 655 on page 923. And the judge's conclusion at the end of 656, the last sentence, I have earlier set out my finding that these aspects of the commercial deal were negotiated and were seen by the SPDs, the defendants, and Greensill as a package or suite of agreements. And then he goes on to say he's considered the claimant's submissions and rejects them. So then 665 over at 924. The judge again reiterates the fact that the agreements were interlinked. Now, of relevance for our case is what is the impact of that factual finding on the meaning of the transaction. And the reason I make that point is we saw in the learned judge's judgment at paragraph 231 that the finding that it's a single transaction was off the back of there being the interlink between the share sale agreement and the dividend. So at paragraph 667, bottom of 924, however, as the claimant submitted and as the earlier summary of the relevant principles shows, the identification of the transaction for the purposes of the claim under section 423 is not determined merely by the factual question whether the agreements, were negotiated or entered into as linked dealings. So, first point to make there is that the judge finds it's not enough that the dealings are linked, in distinction to the approach of the judge. And we say that's a correct application of Brewin Dolphin. And then at 668 onwards, what the judge finds is that the claimants are right. It's just the agreements entered into by the company, the insolvent company itself. And 669, first, the impugned transactions were the only agreements to which GL Greensill was a party or under which it acquired any rights or liabilities. There was no suggestion that the transactions were artificially divided. So that's the first point. 670, based on the case law summarised above, the court will not generally treat agreements to which the debtor is not a party as part of a single transaction for the purposes of section 423. The fact that the agreements may have been conceived or negotiated as part of an overall package is not sufficient for them to constitute a single transaction. So they, we say, are key application in the present case. And then 673, fourth, it was common ground that section 423 requires that the relevant transactions must be entered into by the debtor company. GL did not enter into any of the agreements other than the impugned transactions. So that's the judge's conclusion. Importantly, at 674, the judge deals with the Feakins case. Now, the court will no doubt have seen from the judgment below that the Feakins case was essentially the judge's anchor to her finding that the overall sale transaction was a single transaction. We said that the Feakins case is something else below, as recorded in the judgment. We said it's an instance of the court looking to what the debtor did by a way of an arrangement or an understanding with someone else, even if it didn't actually enter into the agreements, fulfilling the purpose of the statute, namely not allowing a debtor to give away the property. And I mean, I can go through the Feakins case if it would assist the court. Essentially, the problem in that case, as the debtor submitted, was that there were two transactions and the debtor was not party to either of them, that had the effect of overreaching the judgment debtor's interest on the farm. Now, the point that we make here, because we say it's on all fours with the current case, is the rejection of the submission by the defendants in this case. So the defendants submitted that Greensill can nevertheless be treated as entering into the Greensill-Catera transaction. Now, the court's note, page 653, that's the whole series of interlinked dealings that the judge found were a package. The judge says, I'm unable to accept this. There may be cases, so sorry, the submission was that Greensill should be treated as entering into all of the linked contracts by reason of the two contracts that it did in fact enter into, that were within that series of linked contracts. Now, I'm unable to accept this. There may be cases, e.g. Feakins, where a party who has instigated or arranged or procured others to enter into agreements or arrangements is held to have entered into such agreements or arrangements while not being a party to them. However, in the present case, GL did not instigate, arrange or procure the other agreements. On the contrary, its only role in relation to the agreements was at the end of December 2020 when it entered into the final agreements. I am therefore not satisfied that GL entered into any agreements or arrangements other than those to which it was a party.
Do you subscribe to that explanation of Feakins?
My lord, we do. And we, I mean, maybe I will, subject to time, look at the facts of Feakins with the court, so the court can see why the court reached the conclusion it did in Feakins on there being a relevant arrangement. But the point we make here, subscribing to that and on that reasoning, is there is no allegation in the current case that UK CSA did instigate, arrange or procure.
Exactly.
And in fact, it's clear from the judge's factual findings that it didn't. Its role was an afterthought.
Instigate, arrange or procure. GL didn't do it in that case, and you say UK CS didn't in this case.
My lord, no. It came in as a tail end Charlie to declare the dividend as found by the judge, to make good what had been agreed between two other parties, namely the debt-free and cash-free sale. So we do respectfully suggest on ground one that a correct application of the legal principles should have led to the judge finding that the transaction was the dividend declared by UKCS8 and the dividend alone. And we do say that that should lead to ground one of the appeal succeeding.
Yes.
In response to a question of my Lord Justice Newey earlier, what about Sequana? Sequana is the third case because it's another route, we say home, but also we say in terms of direction of travel is on all fours with the points that I've already made on these two cases. Sequana is in volume 2 of the authorities. It's behind tab 16. Now, this point didn't go to the Supreme Court, so the Court of Appeal is the last word on this point. The Director's Duties point did.
Yeah.
Can I maybe outline the facts briefly, because we say they have, as we did to the judge, very real parallels with the present case. And we can start at paragraph 5 on page 410, please. The relevant company in this case is AWA. It's an English company. It was exposed to environmental liabilities in the USA by reason of corporate indemnities that it had given. The amount of those liabilities was uncertain because it depended on litigation in the United States. If we can move to page 412, please. AWA, the company's accounts, contained a provision for that liability, which represented the director's best estimate of the liability. And any assets held in excess of that provision would be a surplus, which could lawfully be paid as a dividend under Part 23 of the Companies Act. As explained,
which paragraph is that?
My Lord, I'm so sorry.
Which paragraph is that?
That's paragraph 15.
15. Yeah. Yeah.
Paragraph 17, important because this is what allowed the declaration of the dividend. So in the early months of 2009, intensive work was undertaken on the provision for the contingent liability to be included in the final accounts for the year ended 31st December 2008. By a process described in detail by the judge, the conclusion was reached that the Maris policy, now that is a policy held as insurance for the claims in the US,
Yes.
that the Maris policy were sufficient to cover the best estimate of the liability, and that therefore it was not necessary to include a provision in the accounts. So the view taken that the insurance policy was enough, no need for a provision within the accounts. As a result of that, paragraph 18, the final account showed distributable reserves of 137 million euros. In accordance with Part 23 of the Companies Act, there was therefore the ability lawfully to distribute them. And what happened on the 18th of May 2009 is that AWA declared a dividend of 135 million in favour of its parent. It did so, as in the current case, by way of set-off against an intercompany debt owing by the parent to AWA. And as in the current case, paragraph 20 of the judgment, that dividend was paid in contemplation of a sale of AWA by Sequana to a third party. Now, as recorded in paragraph 20, the terms of that sale that Sequana would no longer be exposed to the environmental liability, but it would have contractual rights to any surplus received should the litigation in the USA be resolved favourably. And the first instance judgment of Lady Rose tells us at paragraph 42, we can provide the page if it would assist after lunch, that share sale agreement, namely the sale by Sequana of AWA, was entered into on the same day as the declaration of the dividend. So in Sequana, as in this case, the dividend was paid in contemplation of an ancillary to a sale of AWA by Sequana to a third party.
When you say in contemplation of and ancillary, in what sense was it ancillary?
Well,
Was there a contractual provision or not?
my lord, no, just in contemplation of.
Yes.
I mean, similarly, in the current case, there's no contractual provision for the payment of a dividend within the SPA.
But the SPA does contain a contractual provision for the writing off of the debt.
Ah, my lord, yes. Well, to that extent, Sequana is on all fours. That's paragraph 262 of Lady Rose's judgment, that Sequana wasn't prepared to sell AWA without that intercompany receivable being addressed.
But in that case, I'll tell you if I'm wrong. From what you've said so far, it may be in that case there was no need to include an additional contractual provision because the dividend was being paid on the same day as the agreement was made.
My lord, that may be right. I'm not making an additional point in that regard.
Yeah.
So the dividend was challenged under section 423 as a transaction for no consideration. So what the Court of Appeal is doing is considering the no consideration limb of section 423, which is materially identical to the no consideration limb of section 238. And no one's suggested below, and I think suggesting to this court that they should be given different meanings. Now, the Court of Appeal treated the dividend alone as the transaction, and the section 423 claim succeeded. Can I show the court the three issues identified by Lord Justice David Richards in relation to whether the dividend is a transaction as an undervalue? That's page 415. Paragraph 35 of the judgment. So three issues for the court. Is the dividend a gift? If it's not a gift, is it a transaction on terms that provide for no consideration? And whether a dividend involves a transaction within the meaning of the statute. The conclusion of the judge is at page 422 and 423, paragraphs 60 through to 64. And again, can I perhaps give the court a moment to cast their eyes over those paragraphs 60 to 64? So we take 2 points from this. First, it makes clear that the payment of a dividend, declaration of payment of a dividend, is a transaction for no consideration. We say that applies directly within 238 as well. And second, that the payment of a dividend alone is a transaction. Now, we recognise that Lord Justice David Richards doesn't consider whether the wider sale arrangement could be the transaction. We recognise that no submission was made to that effect by the counsel appearing before the court, but we do respectfully suggest that it is an entirely consistent approach to the meaning of transaction with Brewin Dolphin that we've already seen, namely that where an insolvent company declares a dividend, that dividend, the act of the company, is the transaction alone for the purposes of 238. Now, on the facts of this case, it was for no consideration. No one's suggesting anything was going in the other direction. I'm not suggesting there may not be facts in which there could be a different argument around consideration. That's ground 3, of course. Mr. Venstikaisen will deal with that. But insofar as the identification of the transaction, we do say that it provides a yet further very clear steer that the net closes in on and shuts completely around the dividend itself without the more expansive view of the judge. So, subject to the court, they are the reasons why we respectfully suggest the judge did go wrong in law on ground 1.
Thank you.
Can I then turn to ground 2, which concerns the statutory defence? For the court's note, actually maybe we should turn it up. It's page 996 of the authorities, so volume 3, page 996. I'm sorry, I misspoke. It's over the page at 997. Subsection 5. As found by the judge, there are 3 distinct elements. The first limb, A, was found to have 2 elements. 1, a requirement that the company acted in good faith, and 2, a requirement that it acted for the purpose of carrying on its business. And the third requirement is in B, namely that at the time of the transaction, there were reasonable grounds for believing the transaction would benefit the company. Now, it's common ground that the burden of proof is on the defendants to satisfy each of the 3 limbs of the defence. Now, before turning to the judgment, there are 3 framing points we would make. The first is that you only get to this stage of the analysis, namely the statutory defence, if first you've established the company was insolvent, second you've established the company entered into a transaction at an undervalue. So that means your statutory defence is concerned at identifying circumstances in which it is nonetheless allowable for an insolvent company to give away its property for no consideration or at an undervalue. In other words, meaning that nonetheless it cannot be clawed back by an office holder for a pari passu distribution. And we do make the point, I think this really came from the case research from all teams in advance of the trial, that a leading textbook, Macpherson, makes the point in terms that it's rare for the statutory defence to be invoked successfully.
Are there any cases where it has been?
I think there's one case that the parties identified below.
Right. Can we have it?
Of course, my lord.
Thank you.
The second framing point is that the statutory defence, as we've seen from subsection 5, is focused on the position of the company that is in administration or liquidation. It's not focused on the broader corporate group. So the questions are whether it was for the purpose of the company's business, whether it was reasonably thought to benefit the company. And we say that this chimes importantly with the doctrine of separate legal personality of companies, because it's a trite but we say important point, that creditors can only look to the company for repayment of their claims, not to the owners of the company. And where a company is insolvent, it's the creditors rather than the shareholders who are principally interested in the assets. Indeed, we cite the well-known passage from the High Court of Australia in Walker and Wimborne, which was approved by the Court of Appeal and the Supreme Court in Sequana. For the court's note, that's paragraph 35 of our skeleton. So we do say the focus must be on UK CS8, not the position of Rockrose, not the position of its parent, VRO, or any other person. The final framing point is we do respectfully suggest that the learned judge's approach to the statutory defence does have the potential seriously to undermine the purpose and the utility of section 238. Now, I'll make some points by reference to the factual findings in a moment, but there's one point that I should show the court now in terms of how the judge says the provision operates. Could we please go to the judgment? So, tab 7 of the core bundle, page 150.
Paragraph.
My lord, 144, under the heading the issues. So the judge says that there's a substantial legal and evidential overlap between the claims under section 238 and section 423. In particular, the requirement for a transaction as an undervalue is identified in both sections. And now is the point that we respectfully submit is a fundamental error in approach. Moreover, identification of the purpose and intent with which the transaction was entered into for the purpose of section 423 will almost always turn on the same evidence as that required in relation to the statutory defence under section 2385. In practical terms, therefore, claims under the two sections are likely to stand or fall together. If a defendant fails to establish a defence under section 2385, it cannot succeed under section 423. Conversely, if it does establish such a defence, then the claim under section 423 will fail. It is, of course, theoretically possible that a claimant is unable to establish a nefarious purpose under section 423, but that the defendant's statutory defence still fails because there were no reasonable grounds for its belief, or because it lacked good faith, or for some other reason. But such cases are likely to be rare. Now, we say that conflates the purpose and effect of 423 and 238. As the court will know, the absence of an intention to prejudice creditors is what section 423 requires. It is not focused on whether a transaction was entered into by a company for the purpose of carrying on its business. It is not focused on whether a company had reasonable grounds for believing that the transaction would benefit the company. Under 238, one does not even need to show the purpose that one needs to show under 423 to establish a claim. So in fact, it's most unlikely that one will be looking at them in the same context in any event.
The transcriber's taking a break, so we can start.
I'm afraid the transcribers will simply have to catch up from the transcript. We do not take breaks for transcribers in this court. Thank you.
Well, that was my understanding. I didn't pause for that reason.
Yep.
And we do respectfully suggest that the fact that the learned judge sees 423 and 2385 as going hand in hand and standing and falling together, save in rare circumstances, provides a clear flag that the approach to the statutory defence is one which we respectfully suggest is wrong in law. And it's an obvious point, the court will know it, but just to make the point good that I made a moment ago, in Sequana, Lord Justice David Richards highlighted that the purpose of section 423 is different to the other avoidance provisions under the Insolvency Act, as it is focused on the subjective purpose of the debtor. Now, for the court's notes, that's paragraph 29 of Sequana, page 414 of the Authorities, tab 12.
Sorry, paragraph
No, I'm so sorry, paragraph 29.
29.
29, Authorities, volume 1, tab 12, page 414.
I mean, it does sort of suggest that 238 is pointless because you could always have brought a section 423 claim without needing to worry about relevant time or anything.
My lord, yes, which is why there are factual findings that we say shows that in our respectful submission, this fundamental misunderstanding has infected the analysis throughout. But we do say as a starting point.
Now, how did she get that misunderstanding? I mean, you were there? Did you not tell her?
My lord, yes.
Right. And that's okay.
So with those framing points, can I turn to what the judge suggests will be a very rare case, namely, and start in reverse with limb 3, which is the reasonable grounds limb. So the question is whether the defendants have discharged the burden of proving that at the time UK CS8 entered into the transaction, there were reasonable grounds for believing that the transaction would benefit UK CS8. That's the question. Now, of course, if we're right on ground 1, we say the judge has gone wrong in the entirety of the analysis because the judge is considering it by reference to the transaction being the overall arrangement rather than the dividend.
But if I've understood correctly, the defendants say that even if you're right on ground 1, they still win on section 2385.
My lord's understood the point in the respondents. So I'll explain why we say that that's wrong, absolutely. So we say that the learned judge got that point wrong, but we actually suggest that even if the judge was right on ground 1, we still should prevail on ground 2. Namely, even if the transaction has a wider meaning, the fact remains that one element of that wider transaction was the removal of $84 million of UK CS8's property. And one still needs to ask whether a transaction which has that element was entered into by UK CS8 with an objectively reasonable belief that it would benefit UK CS8. So both scenarios the court needs to consider, which we say the judge didn't properly, why the $84 million was removed. Now the judge's answer, as made clear from the court's questioning at the outset, was she felt everything flowed from cash and debt free, and that was enough to answer why remove the $84 million. We, though, on limb 3 say whether we're right on ground 1 or ground 2, the judge's own factual findings are fatal to the respondent's attempts to rely. And just to make that clear by reference to the judgment, can we start at paragraph 186 on page 167? Now, the court's already seen the reference to the afterthought point in the context of the transaction. This is within the judge's overall assessment of what happened. And could I just, I mean, the court may already have this burned on their pupils, but could I invite the court please to read 186 and 187 before I suggest why the judge has gone wrong?
Yeah.
I should say, I'm so sorry, Mr. Slape is the CFO of the company. Just pausing there, I mean, as the court knows, our complaint does and did amount to the fact that UK CS8 had to do something, namely the declaration of the dividend, in the context of the cash and debt-free sale. So to that extent, we complain about the role that had to be performed by UK CS8. And what we say is apparent from the judge's analysis here is that the judge is asking the wrong question. The judge poses the question, was a sale on cash and debt-free terms inherently improper? Now, the right question, we say, when one comes to look at the statutory defence, is you need to look at it from the position of UK CS8 and ask whether a transaction on those terms is one which enables UK CS8 to avail itself of the statutory defence. And we say that the third sentence, the final sentence of paragraph 187, contains a factual finding that we respectfully suggest should be fatal to the statutory defence. Namely, Mr. Mazzagati's own evidence that having agreed a sale on these terms, in other words, having caused Rockrose to enter into the contract with FOIGC on those terms, there was no reason for him to gift FOIGC some $84 million. Now, the judge says that's not only commercially understandable, but entirely reasonable. Now, we suggest the judge is asking the wrong question there. From the perspective of Rockrose, the vendor, Viaro, the ultimate parent, Mr. Mazzagati, the ultimate shareholder, it may well be commercially reasonable and understandable for him to want to keep the money and take it out of UK CS8 as part of the sale. But the fact that he wanted to keep the money in the Rockrose group once UK CS8 was no longer part of the Rockrose group is what led to the dividend, what led to the removal of UK CS8's asset.
But I mean, it's even more simple than that. I mean, Rockrose had entered into a transaction to sell the company, and that transaction had been entered into, and then there was another transaction which was done on the basis that Megazati didn't want to give away 84 million. Who was doing the giving away? It was Rockrose, and Rockrose Group, not UKSC. If you look at the matter through the lens of the UKSC 8, UKSC 8 is losing 84 million to the detriment of its creditors. I mean, it's. I think she gets there because of this cash and debt-free terms, and perhaps she gets there because she thinks cash and debt-free terms is some sort of term of art and something that's very usual, something that's always perfectly acceptable. Is that where it comes from?
I think it does. And my lord, sorry, first, apologies for making the point at length. We gratefully agree with that very pithy summary of what the problem is. But to answer my lord's question, it's within 187. Mr. Jenkins gave evidence that a cash and debt-free sale was a usual practice. So no more than that, no consideration. Of course, a cash and debt-free sale may, in the most general terms, be something that is done in the context of SPAs, but on the facts of any particular case, is it appropriate? And is it appropriate from the perspective of the company UKCS8, which is giving up something? And with respect, the judge doesn't answer questions 2 or 3. The judge stops by saying, well, it's usual practice, so I can give it a tick.
But it's rather...
Sorry, go on.
But it's just rather bizarre, isn't it, that if you look at it from the point of view of the contracting parties to the SPA, FIOGC, that FIOGC didn't have anything to say about 84 million being removed from it at the very last moment and hadn't done sufficient due diligence to understand that the company had 84 million sitting there that could be set off. And I mean, just the whole thing is, anyway, to a cynical judge, as I described myself earlier, odd, which requires an explanation.
I mean, I would suggest it goes further. The emphasis, the judge, is on cash-free, but not debt-free, because there isn't a provision in the
My lady,
SPA
my lady,
that there should be a similar treatment of liabilities owed by the company, which makes the position of the purchaser even stranger.
Even stranger. My lady, we agree.
I would observe that, having had some experience, cash-free, debt-free is started and is fundamentally a method of calculating price, and then you make adjustments. That's how my understanding, at least. But it certainly doesn't extend to a provision that requires a waiver of receivables, but not a removal of payables.
My lady,
I would need some persuasion that could be encompassed by what the judge calls a usual practice.
we agree, and nor points we made, and nor does it contemplate that the declaration of a dividend will necessarily be fine and in the interests of the subject matter of the SPA, because you have this guiding principle of debt and cash free.
I mean, even allowing for the sorts of point my lady was making, there would be nothing wrong in the declaration of the dividend. Suppose for a moment it were a UK company, there would be nothing wrong if there were distributable profits following the dividend. And if the company did not then go to liquidation, assuming that there were no Section 423 point. But where a company does go into liquidation, then Section 238 bites, and the fact that this money was the company's, not Mr. Matsugetti's, is more relevant.
Lord, yes. Now, just contemplating where I go, because I don't want to repeat.
Can I just ask who Mr. Jenkins was?
Yes, he was brought in by Mr. Mazzagatti as someone who had experience in the oil and gas industry to assist with the running of Rockrose.
Not an expert.
No, factual witness. Now, we were going to call the point the unnecessary cash removal point, but the risk of repeating, the court understands our point, which is there's no analysis of UK CS8's position, which the defence requires. I maybe should show another passage dealing with the debt-free and cash-free sales so the court can see how it was made within the context of the statutory defence analysis as well. That's page 196.
What's paragraph?
My Lord, I'm so sorry, it's 257A. So it's when the judge is dealing with the good faith, limb 1.
Yes, I mean, you have to read these paragraphs in their entirety, starting with good faith and going through carrying on business on reasonable grounds.
My Lord, you need to read them in conjunction with all of the earlier paragraphs of the judgment.
Well, of course.
But what to make it clear, paragraph 254, page 195, what the judge says is, I can take the statutory defence quickly because of my findings as to purpose and motivation above. So that's the very end of 254. In view of my findings as to purpose and motivation above, I can take the matters relatively shortly. The judge is going back to and paying regard to all the reasoning when considering the statutory defence as well.
Yes.
So, yes, you need to take it as a whole, but we suggest the judgment as a whole.
We see, I mean, I'm just trying to work out how she got to this conclusion, and it seems to be that she carries over the reasoning in the first section on good faith to the third section, second and third section.
My Lord, absolutely.
Yeah,
very clearly we say.
It's just really all the same.
One has reference back to this section.
This is an impeccable commercial transaction, and if it's an impeccable commercial transaction, it must be in good faith. If it must be in good faith, it must be in the interest of the business.
My Lord, yes. And can I just then to show the court 257. So I argued this could not have been in good faith when Mr. Mazzagatti didn't even know the amount of the debt, namely the waiver under the SPA. The judge says, however, I do not find this at all surprising. The existence of the intercompany debt, namely the debt owed by Rockcrows to UK CS8, the 84 million, was drawn to his attention, Mr. Mazzagatti's, at a very late stage and had to be extinguished, whatever its value, in order to achieve a cash and debt-free sale. In those circumstances, it's hardly a criticism that he simply authorised whatever steps were necessary to write off the loan. The claimant's submission that it was necessary specifically to scrutinise UK CS8's balance sheet before deciding whether the dividend was appropriate presupposes that the dividend itself is the only relevant transaction to be considered. But I've already rejected that approach, which wholly ignores the role of the dividend in the wider transaction. Now, we say, clearly that's it's wrong, the idea that one has to write it off whatever its value because your gold star is debt-free and cash-free and you must achieve it, we say is, with respect, is deeply flawed.
Well, the gold star being cash-free and debt-free is a matter between FGIOC and Rockcrows and of no concern to the subsidiary which has the money.
My Lord, yes.
Yeah. Obviously.
Well, presumably only to the only qualification to that is if one can say that the sale, the different ownership of the company was so significant that it outweighed in some way
And
the
I suppose
benefit of the dividend, which I understand is essentially the case against you.
two points in that regard. One, the only consideration that the judge found moving to UK CS8 as part of a wider transaction, in other words, in monetary terms, was the pension. So the only finding in relation to valuable consideration moving to the insolvent estate was 39.
So she might have thought there was a chance that, I mean, she did mention the chance that they, well, not the chance, but the hope, expectation, maybe, that they would be able to pay the instalment because they had money, because they were, FGIC was apparently connected with the government. But that's not really buttoned down anywhere.
Well, no, it's not. And I think the key point there with respect would be that the judge would conflate two things with respect, even if it were there, which is the question we would respectfully suggest is not whether a sale in the most general sense could help UK CS8 by unlocking any issues as to ultimate ownership and negotiation in relation to the joint venture oil contracts. The question is whether a sale with these terms, including the declaration of the dividend, falls within the defence.
And just thinking around that for a moment, the parties had entered into a contract under which Rockrose agreed to ensure that sums due from Rockrose were written off. That's right.
Yes.
Well, the purchaser was hardly likely to complain if that contractual provision were not complied with.
My Lord, no, and on that, importantly, it has never been part of the respondent's case that FIOGC were not prepared to do a transaction which left the money in Rockrose.
So at the point at which the dividend is paid, well, that's purchaser isn't worried about it. From the purchaser's point of view, the sale can go through anyway.
Yes.
From UK CS8's point of view, well, the sale will go through anyway on the face of it. It's only on the face of it the vendor's interest that's being protected.
My Lord, it is, and that is consistent with the judge's finding as to why it happened. It is protecting the commercial interests of the vendors, not UK CS8.
And supposing it hadn't been written off, what would the contractual position have been? I mean, the purchaser was hardly going to sue the vendor for failing to achieve that contractual obligation. It would have been quite happy. So what could anybody have done about it?
In terms of what could anyone have done, well, from the perspective of UK CS8, nothing, in the sense that it would have retained that asset to be exploited within its insolvency for the benefit of creditors.
UK CS8 wouldn't have done anything, the purchaser wouldn't have done anything. What could the vendor have done?
Nothing, because they are a debtor rather than a creditor.
And at the pre-completion stage, what could they have done other than what they did, which was procuring the dividend?
Not certain that's ever been part of the case. And
I mean, just one clarification on the timing. That this receivable was, as I understand it, this receivable was known about, but perhaps not its precise figure before the SPA was entered into. My understanding.
My lady's right. There was a draft. No one knew when the draft SPA came round. Then they knew that. Then they were told there was one, but didn't know the amount. Sale agreement then entered into without knowing what the amount was.
Although that provision about waiver is an odd provision, might suggest that we don't know when it was inserted in the draft.
No.
But to answer my Lord's question, once you know there's a receivable there, there's all sorts of ways that you could deal with it that don't necessarily involve a dividend. Well, you in your skeleton refer to leaving the receivable or the cash in the company, but there are plenty of other ways that these sorts of things can be dealt with between a vendor and purchaser, including novating the liability to the purchaser. There are lots of ways.
My lady, of course. So it becomes a debt owed from the new parent by reason of novation, of course.
So it's you can't present it as even if you accept that cash-free, debt-free is essential. There isn't only one method.
We would
to
agree.
deal with these sorts of things.
I mean, I think I'm violently agreeing with the fact that one can't go from a cash-free, debt-free mantra to, as the judge do, that must mean that everything is commercially fine and cannot.
Yeah, because otherwise it'd be virtually impossible. Unless if it's a UK company, and let's say it clearly didn't have distributable reserves, you wouldn't be able to sell it on a cash-free, debt-free basis.
True.
If it happened to have intercompany receivables.
Who gave evidence about the cash-free, debt-free motivation? Mazzagatti.
Mr. Mazzagatti did. I mean, I think we cite in our skeleton argument extracts from the transcript where we say he recognises he was thinking about the Rockcrows group generally when deciding whether to declare the dividend rather than the perspective of UK CS8.
No, I'm just interested in where the mantra, which you describe as a mantra, comes from as being the entire motivation.
I think probably Mr. Jenkins, but there wasn't a lot of detail, and there was no expert evidence led.
I mean, was there evidence as to negotiation of this transaction, the wider deal?
The short answer is very little. It was all said to have occurred in person in a hotel in Dubai and led to a 4-page SPA produced by the lawyers without any emails as to the terms of the negotiations. And the judge finds that's the way business is done in the UAE, so one wouldn't expect to see that. I mean, our case was to see a big oil and gas sale like this, one would expect to see a lot of underlying correspondence about the negotiations. There wasn't.
So the cash-free, debt-free was not evidence about that meeting in the hotel.
No, my lord.
Cash-free, debt-free was after the event. This is what it's all about, by Mr. Turner, or whatever his name is.
Mr. Jenkins.
Jenkins.
Yes.
Yeah. And there was only ever one draft of the SPA for this transaction.
My lord, we'll check. It certainly didn't go through the sort of iterations that my lord may be normally expecting. I mean, maybe I can come back to that after lunch. Our understanding is no material movements. It was always, well, again, one of the points we made, an extremely surprisingly short document for this.
This is a very short agreement.
Those instructing me doing these oil and gas deals the whole time, it's merciful maybe to see something under 100 pages, but one tends not to. I mean, this is brevity of really of the utmost.
See, the last page is 3 of 6. We don't know what 4, 5, and 6 were.
So, which page is it in the bundle?
My lord, it's the supplemental.
Actually, the agreement, unless I'm looking in the wrong place, is in the core bundle.
Oh, I'm so sorry, it is. Page 314.
And the last page is 317.
Is there a full version of the supplemental bundle?
My lady, I'm sorry, no, there isn't. This is the version.
Ah, okay. I assume it's only signature pages after.
My lord, my lady, my recollection, it is just signature pages, but those behind will check.
So why do we only have 3 pages there of 6?
My understanding is what is missing is the signature pages within this,
Well,
but I'll check.
Can we be provided with them if they were before the judge?
Of course. That was limb 3 of the defence, and why we say, based on the judge's own factual findings, the statutory defence cannot be established.
So at that point, we're dealing with reasonable grounds for believing that the transaction will benefit the company.
My lord, yes, and of course, if we're right on ground one, we say the transaction is the dividend.
Yes.
If we're wrong on ground one, we say it's the sale, but we say the same core point remains: the removal of $84 million of the assets of UKCS8. And really, we would say the reasoning that's infected the judgment because of the cash and debt-free point is this. The judge essentially accepts the defendant's case that to satisfy the statutory defence, it's enough to show in the most general sense that the concept of a sale of UKCS8 by Rockrose to FIOGC may reasonably have been thought to benefit UKCS8. Now we say that's wrong. You need to look at the particular terms of the sale transaction.
I mean, the point there is that this is all about a situation where the company is insolvent. The company has entered into a transaction which is prima facie not for its benefit because it is at an undervalue. That's all accepted by the judge. And then you are looking as to whether or not the creditors should be protected if the company later goes into insolvent liquidation. And that's the background to the biting of Section 2385. That's the reason it's rare, because in those pre-existing circumstances, it would be unusual if you could objectively say that it was a transaction in the interests of the company.
Well, we agree and adopt that, and I think at the risk of repeating, the reason why the judge appears to have gone wrong is shown in the very first paragraph of the analysis, where there is essentially a statement that 423 and 238 are two sides of the same coin. I mean, I know I'm abbreviating what the judge said there, but saying it's only going to be a very rare case where you fail on 423 and yet the defendants can't win on 2385.
I mean, to go off at a slight tangent, the House of Lords approach in Phillips and Brew and Dolphin might possibly suggest a wider potential application for 2385 in the sense that they say that you can assess consideration retrospectively, so to speak. Even though you take a commercial gamble at the time, it then turns out to be a bad deal, and therefore it turns out to be at an undervalue.
I see. So my Lord's point is there is a factual undervalue because with the expert evidence, with the benefit of hindsight, which it allowed, there is an undervalue. But everyone at the time reasonably believed
Thought it was a good thing to try. I mean, maybe they wanted to pursue some development opportunity that didn't actually eventuate, but it was a reasonable thing to try at the time.
My Lord, we would agree with that. And I think we would also agree that perhaps classic one in the case of a trading company is urgent liquidity need to pay the creditors at your door or your employees at the end of the week. You've only got one realisable asset. You can't get market value in the time you've got. You get a discount due to the time period you have to sell. Provided the court finds it was reasonable to be doing that to try and keep the show on the road, then that's the best you could do in the circumstances. Whereas we would suggest the judge's approach asks instead in the most general terms, well, if you needed to sell something to get money in for the end of the week, then you're within the statutory defence because you needed to sell something. Without considering, well, no, you needed to sell something, but was the price you got for selling one appropriate, taking into account the time constraints, liquidity constraints, etc. The judge's answer is sale transaction, cash-free, debt-free enough. And with the example I just gave a moment ago, it would be we need to sell something by the end of the week enough, which could lead to the company getting a gross undervalue even by reference to the circumstances at the time.
It's not automatic that there would be reasonable grounds for believing the transaction would benefit the company, even if the benefit was chance of staying on the road for another week.
Well, I would absolutely agree. It's one factor the court will be
It's
considering in the
certainly not-
round.
It's not a complete answer. It's, as you say, one factor. But, I mean, what troubles me about all this is the purpose of Section 238, which is obviously to protect creditors in the event of an insolvent liquidation where company directors are entering into transactions in their dying days at an undervalue within 2 years of insolvency and at an undervalue. And in that situation, you start as the company director doing that 2 legs down, and you have therefore to show positively that you had reasonable grounds for believing that this was a transaction which would benefit the company. Otherwise, what's gone before is fatal to you, and the 238 relief follows if your bet does not pay off. If the bet pays off, good luck to you. Creditors are paid, nobody cares. You'd never be in court.
My lord, yes, and we would suggest this is an aggravated example of my lord's consideration of normal circumstances, because it's not a transaction with an independent third party at an undervalue. It is getting assets out the door to the connected party, the shareholder, at an undervalue.
I mean, when you look at Cork, you will see, if my recollection of many years ago serves me right, that some of this is set out as to what it's all about. And it is not about giving carte blanche to any commercial transaction that the directors may think of entering into in the dying days of a company when it's at undervalue, when a company is within 2 years of actual insolvency.
I'm reminded by Mr. Venkatesan that we did, I thought we did, but I didn't want to misspeak, we did cite Cork to the judge.
Super.
So we do have
Find
it. We've got it.
Unfortunately, it's not online. I've got this paper copy, but I can't find it.
That was Lim 3.
Yeah, Lim 2.
I mean-
I see Lim 3, yes.
Sorry, the last
Lim
Lim
3 is
statute.
round 2.
I mean, my fear is I'm at risk of repeating on Lim 2 and Lim 1, because what I called the unnecessary cash removal point really runs throughout.
But you do have to deal with the Delaware law point.
Just before you attempt to deal with that point, you develop in your submissions, your skeleton, a submission that a necessity test comes into it. I just wonder about that. I mean, there's no reference to necessity anywhere in the section. Does reasonable grounds depend on necessity? Does acting for the purpose of the company depend on necessity?
The answer, shall I show my lord the judgment?
If you're coming to it later, then let's do that.
I'm going to come to it later on ground 2. On answering the Delaware law point, subject to the court, we were going to rest on our skeleton in that regard, because it's put as a separate ground within our skeleton argument. In other words, if we're wrong on all the points we've made already, it's another way of what we say is attacking the reasoning of the judge on Lim 3. I mean, I can, of course, if it assists the court, go through it, but it's...
I mean, the thing that troubles me on the Delaware law point is that I completely see that this transaction looks, anyway, to an English lawyer, which adjective to use, but anyway, strange, let's say. But Delaware law seems to be different. And they had Delaware lawyers, and there was no evidence that they were told it was unlawful. And the idea that one should assume against them that it was either known or thought to be unlawful, when you have lawyers acting for you and they don't say you can't do this, I don't quite see how that can be assumed against you, and why the judge is not right on that point.
Two things on that point. Clearly, the judge doesn't reach a finding on whether it was
No,
lawful or not.
absolutely
As a
not.
matter of
No,
Delaware
but
law.
she says they were entitled to rely on the fact that somebody would have told them if it were not all right.
And the short point we make in that regard is, without any waiver of the privilege and disclosure of what they were told, we say they can't do that on their pleaded case.
Because they have the burden of proof.
Precisely, to show that they did reasonably rely on what they were told. And we've had a curtain come down, we haven't been shown anything that they were told, and for that reason we say that they cannot discharge the burden in that regard.
Just thinking about that, is there any evidence as to what they were told? I suppose possibly not, because that would involve a waiver of privilege. It might.
Yes, there's a maybe I can show.
I mean, I'm sorry to just before we. I mean, I think we need an answer to my lord's question, but I'm very troubled about the idea that it can be incumbent in order to discharge a burden of proof to waive privilege. I would need a little bit of persuading of that. The normal position is privilege, and you're perfectly entitled to say, I'm not telling you what advice I had. You can then rely on that and say, well, it's obvious that they had Delaware lawyers. This is known by 14 experts to be illegal. The Delaware lawyers must have told them. They won't waive privilege to say they got it wrong, and so be it. But to actually say that they can't discharge the burden of proof without waiving privilege puts a burden on them that I would find unusual.
My lord, could I consider that point further over the short adjournment, in the sense that we don't need to pursue it as a separate ground?
We'll move on to my lord's point and come back to it. Have you forgotten my lord's point?
Right.
Well, I quite followed that no one had the documentation, or whatever documentation there might be. Was there at least someone saying, I wasn't told there was a problem, or was there even a difficulty about saying that for fear of waiving privilege?
No, well, I think what, and I'll try and find the paragraph of the judgment for my lord in response. I think in essence what Mr. Mazzagatti said is that no one in my in-house team said there was a problem, and they were in contact with Delaware lawyers.
Can I also just ask, obviously Delaware law doesn't have the same principles as the UK Companies Act, but was there evidence before the judge about what the legal framework was?
My lord, yes, there were two Delaware law experts who gave extensive evidence.
Is there or is there not a Delaware law provision that we can look at that relates to dividends not being appropriate if it makes the company insolvent?
The short answer is we don't have it in the bundles, and I think the judge doesn't discuss it in any detail.
I've seen the number somewhere.
I thought I'd seen something, which is why I'm raising it. I thought there's something in the bundle, which just might be helpful by way of context at least. Maybe that can be
just
found.
My lady's remembering, and thank you for the prompt. It's page 201.
18-607, there we are.
Indeed.
18-607, yes.
Well, it does have something that looks somewhat relevant. So the judge is saying there was issues of detail, but no one was saying that that provision isn't in point or relevant.
I'll let you know.
For myself, I think I would quite like to see that provision.
Of course.
Good. Now, taking stock of where we are, if you were not going to address lengthy argument to point 3, where would you be?
I think, subject to anything I'm told from my left, I will be relatively brief after lunch. I've covered ground 1 of the appeal.
Yeah.
I've covered ground 2, limb 3, because we say the points that we were discussing before we moved to Delaware law are sufficient for us on their own in relation to that limb. I was going to deal with, for the purposes of carrying on business briefly and good faith briefly, but recognise that limb 3 is probably going to be the more relevant one, the reasonableness limb, for the purpose of the court's findings.
Right. Okay. Well, we'll resume at 2 o'clock. Thank you.
Court rights at table.